Authoritarians like to excuse due process violations by telling affected citizens, if you have nothing to hide, you have nothing to fear. Yeah? How about you guys go first then? HBR Talk with Hannah Wallen. The Fourth Amendment of the U.S. Constitution protects against unreasonable searches and seizures by government officials. This generally refers to a search and seizure by a law enforcement officer without a warrant and without probable cause to believe that evidence of a crime is present, according to the Legal Information Institute. The amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." This is not only a due process protection defending the citizens' rights to fair treatment in cases of criminal allegation, but also a defense of citizens' privacy and autonomy. In many ways, this is a right that has been trampled in our society, in particular with respect to citizens' rights to bodily autonomy. In professional areas serving consumers whose privacy must be protected, such as those that involve handling of medical, personally identifying, or financial information, there is a standard for sharing information within the workplace in order to limit the likelihood of exposure of private information. It's only transferred on a need-to-know basis. If one doesn't need the information in order to provide the goods or services one is offering to the consumer, one isn't entitled to access it. If one does have access to it, sharing it with a colleague who doesn't need it in order to serve the consumer is a violation of the consumer's privacy. Feminists fought for abortion legalization by describing the subject as a privacy issue. It's not your business, they admonished the other side of the debate. It's not something the government should be involved in, but a private medical decision between a woman and her doctor. Object to that description, and you're sure to hear about how your rhetoric is promoting forced birth. It goes beyond the level of privacy afforded to other medical procedures, such that any government regulation, even when it is similar to regulation of other medical procedures and facilities, is considered a privacy violation. They have even compared vaginal ultrasound to rape, not because it's done without consent, but because under Republican-promoted policy the abortion seeker would not be able to get what she wants without consenting to it. The argument is that she shouldn't have to, and making that a condition of permission for the procedure is the same as forcing the ultrasound on her against her will. All right, point accepted for the sake of argument. Wouldn't that make body cavity searches performed on criminal suspects also rape since they are done against the suspect's will? Those are routine in drug trafficking cases. The question of bodily autonomy and medical privacy touch on a variety of interactions between police and the public. In 2013, a 5-4 split in the Supreme Court upheld a Maryland law allowing police to collect DNA without a warrant from arrested suspects. But in 2016, the court ruled 7-1 that states may not prosecute suspected drunken drivers for refusing warrantless blood draws when they are arrested. This past October, Alex Wubbles, a university hospital nurse from Utah, agreed to a $500,000 settlement with Salt Lake City over her arrest for preventing an officer without a warrant from drawing blood from a patient who was not under arrest. This year, the court agreed to hear the case of Gerald Mitchell, whose blood was drawn without his consent while he was unconscious, and the results used against him in a drunk driving case after he was found unconscious on the beach with his car nearby. In another case, Carpenter versus the United States, the Supreme Court is considering whether police can check his cell phone's whereabouts without first obtaining a warrant. As the New Republic reports, the Justice Department argues that people no longer have a reasonable expectation of privacy when they store their data on a third-party's systems. Digital privacy advocates say that approach doesn't make sense in a world where people have little choice but to keep all sorts of personal content, from emails to text to work documents, on distant servers owned by tech giants. The issue includes questions of privacy related to genealogy databases, putting innocent people at risk for becoming suspects or targets of police investigations, as happened during the Golden State Killer case, when a 73-year-old man in declining health living in an Oregon nursing home was forced to submit to DNA testing after police obtained a warrant based on information from genealogy websites. This technique eventually led to former police officer Joseph D'Angelo, 72, after investigators matched crime scene DNA with genetic material stored by a distant relative on GEDmatch.com. GEDmatch said in a statement that law enforcement never approached it about the case in California. In another similar case, Minneapolis law enforcement recently used information from a genealogy website to identify Jerry Westrom as a suspect in a 1993 murder, then tailed him to an event where he purchased and consumed food and used residue on a napkin he discarded to obtain DNA to match up to the information they had. In December 2017, an article titled "How Forensic DNA Evidence Can Lead to Wrongful Convictions" was published in the Science and Technology section of JSTOR.com. In addition to the ethical questions surrounding methods used to obtain DNA evidence through genealogy sites, forced blood draws, and cheek swabs, it raises the issue of DNA similarity among family members, citing a 2002 case in which DNA from a 1988 murder scene led to a boy who was too young to have committed the crime, after which his family members were tested, leading to another match, who then confessed, leading to an arrest. But what if the boy had been a man, still innocent, but old enough to qualify as a suspect and unable to prove his whereabouts at the time of the murder 14 years past? Would he have been able to clear his name? The article points out that DNA profiles are often not clean enough to conclusively identify an individual. Often authorities are only able to obtain samples which are damaged, leading to partial profiles which can only have limited application as a means of identification, and even full DNA profiles can match with a person other than the culprit. A report cited in the article describes such a case. In 1999, Raymond Easton, a 49-year-old man from Swindon, UK, was arrested and charged with a burglary in Bolton, UK, 175 miles away, after a DNA sample from the crime scene matched his DNA profile in the UK National DNA Database. Mr. Easton was in the advanced stages of Parkinson's disease and was unable to walk more than 10 meters without help. His DNA profile had been loaded onto the database 4 years earlier following a domestic dispute. The crime scene sample matched Mr. Easton's DNA profile at 6 loci, which was considered enough to secure an identification at that time, although the total number of STRs, short tandem repeats, required since has been extended to 16 plus a sex marker. The chances of a match was reported as 37 million to 1. Mr. Easton spent several months in custody before his solicitor persuaded police to run further DNA tests, which eliminated him. For reference, loci are specific identifiable places in human DNA where there is variability between individuals, and short tandem repeats are small sections of DNA found throughout the human genome, which are made up of short sequences that are repeated. The fallibility of DNA evidence as a means of identification doesn't rule out the use of DNA as a means of excluding an individual from suspicion if results show he or she is not a match to the perpetrator's DNA, but it means that an individual should not be convicted on DNA evidence alone, and massive DNA databases may be as likely or more to lead investigators on wild goose chases as to identify perpetrators. It is in the context of this information, the privacy and civil rights issues, and the fallibility of DNA evidence just described, combined with the fact that DNA evidence from genealogy databases is being used to determine suspects in criminal cases, that we examine a recent news report out of Arizona, as azcentral.com and other sources have described Senate Bill 1475, introduced by Republican Representative David Livingston, which would mandate DNA collection from some Arizona workers. Initially, the bill would have mandated collection from anyone required to be fingerprinted by the state for a job, or to volunteer in certain positions, or for a myriad of other reasons. It also would have authorized the medical examiner's office in each county to take DNA from any bodies that came into their possession. This collection was to be used to create a massive statewide database of DNA. AZ Central reported on February 19th that the bill had been significantly scaled back to only require DNA from professionals who care for patients with intellectual disabilities in an intermediate care facility. According to the article, the changes were quietly made Tuesday afternoon amid public outcry following a story by the Arizona Republic describing the specifications of the original bill. The article goes on to speculate that the bill's focus is on addressing a recent incident involving an incapacitated patient of an intermediate-level care facility who was raped and impregnated. It was introduced not because the culprit couldn't be identified and convicted, he was, but in order to expedite such investigations by ensuring the DNA would already be on file. This raises the issue of whether people in certain positions of responsibility should be required to give up their right to medical privacy in order to do their jobs, on the excuse that a small percentage of people within their professional areas might commit crimes, and whether taking a job in such areas should constitute consent to waive one's right to due process, including the limits of lawful warrantless search and seizure. Is there a citizen's right to privacy, as abortion advocates claim? Is your genetic information yours? Is it personal, like your social security number and your medical history, to be shared only on a need-to-know basis? Or is it state property that you can be commanded to hand over on the basis of your non-government job? Will this information be used to determine paternal responsibility when the state is trying to offset welfare costs with child support obligation? Could it be used to track down sperm donors? And would it confer responsibility that would otherwise never have been in question? Ultimately, who is going to have access to this information, and for what purposes can it be used? How big of a can of worms are we going to open here?